My name is Christian Cisan. I'm a partner here at LOIS Law Firm. This is the New York Workers' Compensation webinar series. And what we're going to discuss today is how to define these claims, how to defend them, and how we go about getting apportionment once we reach permanency. As a reminder, this is a live question and answer session, and since I just spent the first 2 minutes saying empty words into the microphone, now you can hear me and hopefully put in questions that don't say, please turn the sound on. Great, great. Okay, we do know that there are physical traumatic injuries. They are the most common work accidents in our state. There are mental injuries as well. But what we're here to talk about today is the exposure or repetitive trauma cases, right? We like to term them retirement programs because they actually probably should be falling into the physical traumatic claim, but unless it's a true exposure over time where you can't actually pinpoint where one date occurred that would have resulted in the injury, a lot of these repetitive trauma cases are problematic because, one, claimants do not provide notice to the employer in a normal case, right? They don't fill out an incident report saying that over the past 35 years as a carpenter, I now have carpal tunnel syndrome from using a hammer, right? When that process gets delayed, it's on us to really make sure that we're defending from day one. Death claims are also another type. They are occupational in the sense that they require the same types of investigation into a defense, but they're not treated under Section 44 or 28. So when can these claims be compensable? When they result from the nature of the employment and when they're caused by a distinctive feature of the employment. Those are actual buzzwords used in case law. I like to actually term them as the surroundings and the stuff that you give them to actually work, right? So if I work in an office building, everything that's part of that office building that I touch or that I use and the surroundings that are encompassing me as I do my job would be part of an occupational claim. On the surface, it seems very friendly to claimants, and of course, it's very friendly to claimants. Otherwise, we wouldn't be even talking about this. This is New York Workers' Compensation law, or as judges like to put it, it's not employers' compensation law. But how do we do this? How do we defend against these claims and show that we are not going to take them lying down? Well, the first part is a statute of limitations defense. The claimant must bring the claim within 2 years of when the employee knew or should have known, and within 2 years of being disabled, whichever is later, right? So the key here is the knew or should have known part of the process, right? You go to trial, it's very, very rare that a claimant is going to admit during his or her testimony that, yes, I knew about this 18 years ago, and I didn't file it until 2019 because I just felt like retiring. That is never going to be something that's going to be testified to, so we have to actually throw enough stuff at the wall so that the should have known aspect becomes more clear. So the first thing we're going to do is look to the medicals, right? When was the condition known to the claimant? Cross-examining the claimant is very, very important, and it's actually coming at them not so aggressively, right? They are someone who is going to be predisposed to wanting to testify to the nature of their injuries, how serious it was, how much it has affected their life. Playing into that is a good strategy as opposed to just knocking and drumming on the same door all the time. And in order to do that, you have to set up the case, right? What are we doing to actually get to a point where they are giving us the info we need, right? Are we securing the right medical releases? Are we involved with knowing who their prior treatment was rendered by? Are there medical canvases that could show where the treatment has taken place? Is there surveillance, social media reports that can show what they're doing on a daily basis to get us to that point? Everything leads to a mix where we can cross-examine the claimant and find out when was this condition known. Once you figure that out, it's a simple math problem of adding 2 years to the filing of the claim and presenting your statute of limitations defense pursuant to Section 28. Now, if we have to deal with date of disablement, right, we're getting to the point where we're defending it from a coverage standpoint, there are a few dates we want to be aware of, right? First is the date that the employee first lost time from work. right? This is your typical retirement program where you're going to see someone essentially retire for reasons unrelated to the accident, but then file a claim saying that the injuries that he or she is now suffering is that predecessor or that stimulus that required a lost time from work, right? If we want to push that date out of our coverage period, we want to make sure that our counsel is aware of prior policies that are in place, coverage searches for the right employers, meaning has this employer done business at other locations that would require different policies. Another thing to look at would be dates of medical diagnoses, right? When the claimant is diagnosed with a condition, is it 2 years out, or should this have occurred during another carrier's policy period, is something we want to take a look at. Actual exposure is also something we want to discuss, right? A lot of instances will involve claimants alleging being exposed to certain toxic substances at work. There might be some dangerous activity being performed at or near the location, and we want to create an actual timeline that shows when exposure took place. And we have had some success looking to different alternative sources of showing when exposure actually took place. There's a huge list here on my right, your left, I think. Maybe I have the directions mixed up, but quality reports, hygiene reports, sampling. So sometimes OSHA will come on and do some testing at the site to determine whether a workplace is safe. Any union records, ergonomic or noise studies, all of these things can be used as probative evidence to discuss when actual exposure took place. Now, when we get to the point where exposure, date of disablement, and statute of limitations is either being developed or being disregarded, maybe it doesn't apply, your IME is going to be a good indicator of how you can defend the claim, right? Using those forensics reports to give to the IME, using job duty details to give to the IME. The IME should not only be looking at medicals that are in the board file, because the medicals in the board file are actually the ones that the claimant is using to establish the claim. And we see a lot of those IME reports that state, well, if the history is true, then that means causal relationship is conceded. And that's a big problem here because we are not in those rooms to give the IME the clear picture of what the case is actually like. I always say that if you can discredit the history, you're also discrediting the diagnosis. If you're discrediting the diagnosis itself, you're running an uphill battle because we are not medical doctors ourselves. Complete medical history is also going to be a big part of this. I just mentioned about how we don't want to use just the medicals in the board file. So how do we do that? We here at LOIS always request HIPAAs from day one when we get that file coming in. If the HIPAAs are not being returned, those cases have to be removed from the expedited trial calendar, which means that, yes, generally in an occupational case, you might be able to get that irrespective of the HIPAA issue, but it adds another layer to the argument to buy time for your investigation so that you can subpoena prior records, get them to the IME, and give them a more informed basis to provide a causal relationship opinion, right? And of course, once you get there, the goal is to show that this condition pre-existed the employment or it arose during prior employment, right? These are not just your garden variety causal relationship versus no causal relationship opinion. There are a lot of factors that go into whether it occurred first and if it did, when it occurred. Okay, apportionment is very difficult and it's very hard to understand. So I'm going to go through it a little bit more slowly, and I'm assuming that a lot of the questions at the end will be about this particular issue. So please let me know if I didn't go over an issue that you've been having trouble with. This is codified in section 44. Okay, that's just a baseline of where you want it to look at. That actual statute is very, very short. So if you have a few seconds after the webinar and you want to get some context, feel free to look it up. It's not one of those long statutes written by someone who just wants to make your life hell. It basically says that the last employer is the one liable, but that employer can seek apportionment from employers and carriers who expose the employee to the same condition leading to the occupational disease. Now, if this is done perfectly and ideally, then that means we actually know who the prior employers were from a defend from day one standpoint, meaning what resume was the claimant using to apply for the job and what prior employers did he or she say he worked for. Or there's a coverage search being done prior to the pre-hearing conference, which shows all the possible carriers that could be on the risk. A lot of these issues can be addressed early to protect yourself in the future, right? We don't want to look at apportionment as a way to get out of a claim at all, because it's the last employer that's on the risk that's going to ultimately be hit with the present liability, but future liability will result in reimbursement if it's done correctly. Okay, so a few important concepts within apportionment. First is the date of disablement, right? Usually it's the first date that the claimant couldn't work or the first date the claimant sought care, but the board has a lot of leeway in determining this date. And I like to think of this date as one in which our policy either applies or does not apply for exposure to our employer and providing benefits to the claimant, and also as an anchor, right? In opposition, we talk about a date of contraction, which is when the claimant first registered complaints. And this is your prior anchor in relation to the subsequent anchor which is date of disablement, because all the employers and carriers that are now in between date of contraction and date of disablement could now possibly be brought in to try and get some reimbursement for the liability you may be established with. Last injurious exposure is another term of art. It has to do with what we talked about in a prior slide, actual exposure. But the important thing for this case is for this term is to know that only employers who actually exposed the employee to this risk are ones that can be brought on for apportionment, right? It's theoretically possible for someone to do different types of work for the last 20 years, but not all jobs could have exposed the person to the risk and to the occupational disease. Okay, so how do we get apportionment? Let's start with schedule loss of use cases. This is a little bit easier than a non-schedule occupational claim, so we'll start here. In these cases, you can apportion to work and non-work disability. And it's easier, obviously, for a work-related disability because it's easier to get records and it's easier to find a link between scheduled loss of use from a prior work injury to a prior non-work injury, or compared to a prior non-work injury. It's actually very similar to apportionment in a scheduled loss of use traumatic accident case. You're more likely to succeed in apportionment in this arena, one, because it's easier, but mostly because specific traumatic injuries are documented. It's very easy to say when something occurred 10 years ago, how the claimant's medical looked back then, and how it looks now, as a way of finding an opinion to determine which accident is more responsible for current permanent disability. Now, for non-schedule classification cases, usually ones that involve loss of wage earning capacity cases, this is a little bit difficult, but it's not impossible. So don't automatically think that you're out of apportionment. You can do it. It's just a different standard that can seem impossible, right? The actual phrase in case law is called disability in a compensation sense. So the prior condition must have been symptomatic and disabling prior to the new injury, right? And a lot of industry experts that you'll deal with in this space will talk about whether the claimant returned to full duty in between both incidents. It's a lot more difficult to establish disability in a compensation sense when they return to work, but it's not impossible because there are diagnostic findings usually on prior cases that can compare findings that are present when a claimant returns to work and that are still consistent and relevant and existent now in order for the claimant to pursue a claim in the future. Okay, there are exceptions to apportionment. So not every case is going to be pursued from our side in this way. A big example is dust diseases. That's section 44A. That statute is actually one sentence, so you can actually take a few seconds to read that on your own time. It basically excludes dust diseases from apportionment. The other issue is loss of hearing under section 49-BB. It's a little bit of a loophole, which actually doesn't let you go about apportionment in the same way. I'm sure there'll be some questions about that, and I'll be able to answer them as well. Okay, so we've gone through about 15 minutes of discussing apportionment and occupational diseases, what they are, how to defend them, and how to go after reimbursement. I'm sure that there are some questions, so I will now see whether this is the case. So the first question I have is from Kathleen, and it's, can you apportion a workers' comp claim to a VFBL or VAWBL claim? And the answer is yes. It really depends on the fact pattern within those claims. So it's not the actual claim that will preclude you from apportionment. Again, it's disablement in the compensation sense, and it's really going to be a case-by-case basis. So actually having a claim in particular will help you answer that question, because the medical reports and the diagnoses and the testing done within those cases correlated with whether the claimant lost time from work, and had it been a regular workers' compensation claim, would it consider him disabled, then apportionment would be possible. So thanks, Kathleen. And it looks like that's the only question we have here today. So I hope everybody trudged through my early snafu with technology. I did not have a working microphone, but if anybody has questions on how to define an occupational claim, how to defend them, and how we pursue apportionment, please feel free to contact me or any one of my delightful attorneys here at LOIS Law Firm. Other than that, my name is Christian Cisan, reminding you guys to defend from day one.